Happy Monday after Thanksgiving. I want to let you all know that on Wednesday before Thanksgiving, we had our hearing in the Senate Bill 5078 case, which is our gun rights case. If you don't recall, Senate Bill 5078 modified revised Code of Washington 9.41 by prohibiting the manufacture, sale, transportation for sale of any large capacity magazine, meaning it's got the capacity of 10 rounds, more than 10 rounds. So we went to Yakima and challenged that, and we had our hearing in the federal court. Our plaintiffs are phenomenal. Scott Brownback is a great guy, great attorney up there in Yakima Valley. Gimme Guns, great small independent store that's trying to make sure that you have access to your constitutionally protected firearms and the rights there too. So, the hearing. We were there on a request for preliminary injunction, meaning we asked the court to tell the state to not enforce any of the effects of Senate Bill 5078. Again, those amendments to revised Code of Washington 9.41. In that hearing, I thought the judge was pretty fair. She did ask about 5 or 6 questions. All 5 or 6 of those questions were directed at me, not opposing counsel. And they fundamentally rested on 2 things. One, and these are real critical elements to obtaining a preliminary injunction. Mr. Serrano, what is the irreparable harm your clients would suffer if I don't enjoin this? And 2, what are the damages associated with any enforcement, etc.? So, important case law. 1976, Elrod versus Burns, without getting into it, it's a First Amendment case. The Supreme Court of the United States held that any impact to your constitutionally protected rights, any infringement of that right, constitutes irreparable harm. Importantly, in the near 50 years, Elrod has been extended to not just the First Amendment. We've seen it in Fourth Amendment, Fifth Amendment, Eighth Amendment, and most recently in Second Amendment cases. A lot of the Second Amendment cases came from the Ninth Circuit. That's where we will end up if this is appealed. That runs Hawaii, California, all the way to Oregon and Idaho. Guam, I believe, is in there, and Alaska too. It's very important that we have good case law established. Now, the state and the interveners argued, well, Mr. Serrano's relying on cases that were vacated because of the Bruen analysis. That's it's fair, it's true, but not important. Those cases were not vacated because they're bad law. They were vacated because those cases actually turned on the question that was important under Heller, the prior gun case law, which was if there's a constitutional right that's impaired under the Second Amendment analysis, then you're going to turn to what level of scrutiny. And then the state has the ability to say, well, we have a compelling interest in stopping this action, in this case, the prohibition on sales of magazines, and that it's a compelling state interest, therefore we win. Now, under Bruen, the question is fundamentally it's whether or not the actual act that's prescribed by the law is protected under the Second Amendment's text. If that's the case, then the state must show a history and a historical tradition of actual regulation of the prescribed activity. Again, sales of magazines. And we believe 2 things. One, that the state failed to make such a showing. There's no historical tradition of that impairment. And 2, because of the way these cases that I relied on that assert that the Second Amendment infringement for any period of time is irreparable harm, even though they were vacated under Bruen, that it doesn't undo the analysis. Not for that component. What it would have done is it would have forced the state or the government or the judge to make a decision not on whether the government's shown a compelling interest, but whether or not historically these regulations have been found consistent with the Second Amendment. And so when I said, hey, look, these cases out of the Ninth Circuit are telling us that any infringement on the Second Amendment is irreparable harm, not could be, but is, to me, that case law is still good. So whether or not the judge sees it that way is going to be one of the really critical elements of her decision. So wrapping it up, there's that element. And then as far as that irreparable harm as compared to the greater good, again, infringing on constitutional rights as compared to potentially, and I want to say it was potentially prohibiting mass shootings, because that's what the state relied on. Of course, the timing was such that we had the Denver nightclub as well as the Walmart shooter in Virginia, within like 48 hours of our hearing. So that was a little unfortunate. But of course, the state played on that emotions, right? That side of emotions. And so we stuck by our guns, no pun intended there, but we stuck by our guns and said, listen, this is irreparable harm. Shutting down constitutionally protected activity is irreparable harm. That is a damage, and that is a damage not just to the two plaintiffs, but to all of society. Shut down one constitutional right and don't have repercussions for the government, shut down all of them. That's our concern, and that's what we were there for. So we sought the injunction. The judge said she'll rule within 30 days, probably 27 days from now or less. So as soon as we have a hearing, we'll let you know, or as soon as we have a ruling, we'll let you know. We'll let you know what the next steps are. It's really dependent on what she rules and how she rules it, to see what the challenge looks like from either side. I suspect if the injunction's issued, we'll have an immediate appeal. If it's not, we're going to weigh the analysis as to whether or not we want to do a bunch of supplemental briefing and then seek a permanent injunction, or whether or not we feel comfortable appealing on our current record. I'd really like to supplement the briefing because there's been a lot of activity, again, throughout the Ninth Circuit where we've had some solid experts weigh in on there's no historical tradition. That is critical. I mean, if she misses the point that it's a constitutionally protected activity, we have to bring that historical analysis, and we will. We're going to do what we need to do to protect your constitutionally protected rights, and ours too. That's what we stand for. We will keep fighting for you. God bless. Please keep supporting. Follow us, smfjb.org. We're on Facebook and Twitter and Instagram. I've been told we're making a Truth Social, apparently Rumble too. Stuff that's well beyond my pay grade. I'll keep fighting in court. You keep fighting and getting the word out. And where you can, please donate to our cause. We absolutely need your continued donations. Where you can subscribe to monthly donations, please do so. We are spending every bit of every dollar we get to make sure that we have the staff to make sure that your rights continue to be protected. God bless. Have a great day. Thank you.